Hello, Year 11 legal class. It's been a long time between videos, so hopefully you are excited for this because I'm going to pretend to be excited for this because we are starting a new topic. And as always in a new topic in legal studies, we're going to briefly talk about the new topic and then we are going to do the principles of justice, fairness, equality, and access for the 1000th time. So strap yourselves in. It's going to be a hell of a ride and let's get right into it now. Also, if you're wondering about this headband, it used to be Rachel's headband, and then eventually I stole it because it helped keep my fringe out of my face when I was doing exercise, and now I ironically just enjoy this pink headband with pineapples on it. So that's just part of who I am. So what we're doing for outcome two, all about remedies. Essentially, it's the same as our sanctions topic, but from a civil law perspective. So we're looking at how people are restored to their original position in civil law cases, compared to before how we're looking at how people are punished for breaking criminal laws. So on the completion of this unit, the students should be able to explain key concepts in the resolution of a civil dispute and discuss the principles of justice in relation to the resolution of civil disputes and remedies. So do some good teach, some learning intentions and success criteria. So hopefully at the end of this lesson, you'll be able to define what a remedy is, you'll be able to identify the parties of a civil dispute. You can probably already do both of those things, unless you haven't been listening so far this year, in which case I'm secretly judging you. And to understand how the principles of justice are applied in civil cases. So if you can do this well, you can accurately and fully define what a remedy is. You can name and define each of the three principles of justice. If you can't do that by now, I'm worried. And you can explain each principle of justice and how it is applied to civil cases. You've had to do that in every single SAC so far. You've done it for civil cases in the previous, like Unit 1. So hopefully this is just going to be a little bit of more of the same, but you're going to be doing it better because you're older, wiser, and smarter. So what a remedy is. So civil law looks at solving disputes between people where rights have been infringed or a civil law has been broken. So what are some examples of rights being infringed? Well, if you look at the world at the moment, a lot of people think their rights are being infringed by the lockdowns that exist and being told to wear a mask. And they're quoting the Human Rights Act of 1948, and they're wrong because the Public Health Act supersedes that and overpowers a lot of it. So let's not worry about that. But some examples of rights being infringed can be pretty simple. Someone can trespass on your property. Someone can be negligent towards you and breach their duty of care. You might just have a noisy neighbor. That can infringe upon your rights and you can take action against them if they are impeding on your ability to enjoy your own land. I read yesterday there was an example of people who were making too much noise in Wyndham Vale, and the neighbor dobbed them in, and it was 5 people having a party in a garage and they all got the $1,652 fine. That's a criminal side of things, but just an example of why you don't want to be noisy, especially in the current pandemic. So the person whose rights have been infringed, who's known as the plaintiff, seeks a remedy or a solution to address the breach of their rights by the defendant. And a remedy is a legal solution for a breach of civil law. So most of the time we see that in terms of what we call damages, which is usually in the form of money. Other times it can be as simple as an apology or a retraction if it's a defamation case, or it can be making someone finish off a contract. Therefore, so if someone starts building a fence and then just stops, even though you've paid them to do the whole thing, you can force them to go back and finish it off. It happens in sports a bit where people try and get traded before their contract's up and the club then forces them to see out the rest of their contract. So the remedy should provide compensation for the infringement of the plaintiff's rights and aim to return the plaintiff to the position they were in before the infringement took place. Not always 100% possible. So for example, negligence cases, sometimes someone can be severely injured to the point where they might be handicapped, and you obviously can't take them back to their original position. So often it may just end up being a case where they give them a monetary equivalent of doing that. And so the second question there, we've kind of already answered the first one, but do all civil cases need to involve only human beings? Well, no, you can sue a company. Most famously, we looked at the McDonald's hot coffee case when we looked at this in Unit 1, where the woman poured hot coffee on herself by accident or spilt it on herself, sued McDonald's, as a company, because the company in that case was negligent. So it's not always just human beings. It can often be companies. You hear stories of people slipping over in Woolworths or Coles and suing them. You can sue a company. It's not always just human beings. So then we get on to our 3 principles of justice, which hopefully you are experts in right now. So we'll probably just smash through them pretty quickly. So fairness requires fair processes and a fair hearing. It means that the parties in a legal case should have the opportunity to know the facts of the case and have an opportunity to present their side of the case. One way fairness is upheld is the procedural requirement that both parties list the documents relevant to the dispute and provide copies to the other party. This means that both parties have all the information and know what's going to be presented in the court, so there are no surprises and it is fair. So this means they can prepare effectively prior to the trial or hearing. Then we have equality. So equality means that people should be equal before the law and not treated differently due to any personal attribute or characteristic. They should be treated impartially without any bias or prejudice by the adjudicator, regardless of their background. One way equality is to be upheld is through the use of a civil jury, whose members must have no connection with either party and who make a decision based only on the information presented in the trial. Further to this, by seeking to ensure that certain groups like people with disabilities, mental health issues, or low socioeconomic background are not disadvantaged. So say, for example, if you're from low socioeconomic background and you can't afford a lawyer, one is provided to you by the state. That achieves a little bit of equality because they are able to be represented and they're not just left to represent themselves. And lastly, we have access. So access is all about people being able to understand their legal rights and use procedures, methods, and institutions that resolve the civil dispute and their case. This includes the courts and tribunals and institutions that provide legal advice, information, and education. So this means we've got a lot of things like legal aid that provide information and advice to people who might not be able to access the law normally, which is great because it means people have access to the law and can understand their rights a little bit better. People should be able to get information about their rights when these rights might be infringed and what remedies are available to them. However, this is not always the case, especially for those who live in rural areas or have little understanding of the legal system. So it can be problematic when there could be language barriers, they could be from a different country and not understand laws in Australia. A lot of people's rights have probably been infringed and they've never known about it because they don't fully understand the law. And that's a bit of an issue. That's why access is so important, because if people are able to access the law and understand the law, they're able to make sure that their rights are not going to be infringed. That's basically it for this first little bit. Obviously, the same as most other topics to start with. I'm just tying in a little bit of what the topic is with the principles of justice because they're always going to be important. They're going to be even more important next year. And then we'll go on to the other more interesting parts of the topic. So other than that, probably I've written on Teams where you are meant to do some EdRollo questions. And then that is it for the day. So I hope other than that, you have a wonderful day and I will see you later on. Goodbye.